So the Supreme Court recently forced the Fourth Circuit to rehear a ban on so-called assault weapons and so-called large capacity magazines, and they forced the Fourth Circuit to use the correct type of historical analysis. And the Fourth Circuit recently held those oral arguments. So let's talk about this. But real quick before we jump into this video, if you think it's time for assault weapon bans and magazine bans to be completely struck down, go ahead and hit that like button and subscribe. Also want to thank the sponsor of this video, which is Sonoran Desert Institute. SDI is an accredited online college that helps students learn the skills and techniques they'll need to be successful in the firearms industry. So if you enjoy gun repair, ballistics, and learning about firearms, SDI might be a good option for you. To find out more about SDI, you can visit them using the link down below. As I mentioned in the intro, the Supreme Court recently forced the Fourth Circuit to rehear the state of Maryland's ban on so-called assault weapons. The case we will be discussing in this video is called Bianchi v. Frosch. This case is seeking to strike down Maryland's unconstitutional ban on so-called assault weapons. Now for some quick background on this case, why it's so important, and how we wound up where there's oral arguments once again at the Fourth Circuit. The state of Maryland identifies certain rifles as so-called assault weapons. Maryland bans the sale, transfer, or possession of semi-automatic centerfire rifles with detachable magazines and two offending features like a folding stock, a grenade launcher, or a flash suppressor. There are some workarounds in the state of Maryland where the state of Maryland has some things called the heavy barreled rifle rule, but in reality, it's still a ban on so-called assault weapons, and that's what's being challenged in this lawsuit. This ban was challenged in a Maryland district court. In the original complaint, the plaintiffs conceded that their Second Amendment claim was foreclosed at the district court level based on a prior Fourth Circuit decision on this very issue. That prior case was Colby, and Colby challenged Maryland's assault weapons ban. In the Colby case, a district court upheld the Maryland ban using intermediate scrutiny. On review, a divided panel in the Fourth Circuit concluded that these rifles are protected by the Second Amendment and that the ban substantially burdened the right of self-defense within the home. On that basis, they struck down the ban in the state of Maryland, and they used that using strict scrutiny. Well, the state of Maryland didn't like that, so they sought an en banc rehearing at the Fourth Circuit level. On review, the en banc panel in the Fourth Circuit upheld the state of Maryland's ban, finding that these rifles are outside the protection of the Second Amendment because they are useful in military service. So that was the Colby case, which currently still stands as precedent in the Fourth Circuit, and they found that under the military use test, these type of rifles could be banned by the state of Maryland. This case, Bianchi conceded Colby is the controlling precedent, but that it's incorrect and should be reversed. The district court in this case, Bianchi, ultimately dismissed the complaint for a failure to state a claim because of that prior precedent. That dismissal was then appealed up to the Fourth Circuit, and the Fourth Circuit once again upheld the dismissal, again because of that Colby precedent. Then this case eventually went up to the Supreme Court level and was seeking Supreme Court review. And for a while, the Bianchi case sat on hold at the Supreme Court level because the Supreme Court was reviewing a different case called New York State Rifle and Pistol Association versus Bruin. The Supreme Court ultimately ruled on the landmark Second Amendment case Bruin and found, among many things, that the correct way to review these Second Amendment cases, like the Bianchi case, is to look at the text of the Second Amendment in light of relevant history and tradition. The relevant history is that dating back to 1791. The burden is on the government to find a historical analog dating back to 1791 to justify their restrictions. If they cannot, then the restriction is unconstitutional and must be struck down. Now, after issuing that ruling in Bruin, the Supreme Court then issued a GVR in the Bianchi v. Frosch case. That means that the Supreme Court granted review, vacated the lower court decision, and sent the case back down, remanded it back down to the Fourth Circuit for them to reconsider the case in light of Bruin. That reconsideration requires that this case be reheard using the text as informed by relevant history and tradition standard. This case was then opened back up at the Fourth Circuit level, and the Fourth Circuit recently held oral arguments before a 3-judge panel. That panel had judges Niemeyer, Thacker, and Richardson. This was an interesting contrast where one of the judges was clearly a bleeding heart anti-gunner who wanted to completely ban these types of rifles, and then you had 2 judges who understood the right to keep and bear arms, understood what the Supreme Court did in Bruin, and wanted to faithfully apply Bruin. It was also interesting to see how the state of Maryland is ultimately trying to weasel their way out of Bruin having any impact on this specific lawsuit. During the oral arguments, the state of Maryland argues that the Bruin decision actually does not have any impact on their assault weapon ban and magazine ban and has no impact on this case. In fact, they argue that the Bruin decision only applies to concealed carry laws. They state that the Colby military use test and the Bruin text as informed by relevant history and tradition standard, can coexist, but that Bruin doesn't override the military use test. Now, in my opinion, this is just a weak attempt by the state of Maryland to try and essentially have Bruin have no impact on the Colby decision, to prevent Bruin from overruling Colby, which clearly it does. And a lot of the judges saw through that and actually called the state of Maryland and their attorney out on this very fact. And they were struggling with, well, how can you say that Bruin does not override what the en banc panel in the Fourth Circuit said in Colby? The Fourth Circuit judges who heard this lawsuit present to the state of Maryland's attorney that it's the Supreme Court who are the ones that GVR'd this lawsuit and remanded it to be reconsidered in light of Bruin. So how could they say that Bruin has no impact on this case? Also, the analysis in Heller and Bruin was not this made-up military use test. So how could they say that the military use test is not overridden by what the Supreme Court just said in Bruin? The state's main argument seemed to really be that Bruin doesn't apply here in this case, but outside of the one anti-gun judge, I don't think the other judges really bought that argument. So then the state of Maryland said that, well, if Bruin does apply in this case, the court here, the Fourth Circuit, needs to remand this case back down to the district court for a record to be developed on discovery. They mentioned that they would then find evidence like we see the state of California do and what they presented in the Miller v. Bonta case, and they will try to show how AR-15s are not in common use for self-defense. The state of Maryland tries to argue that the common use for self-defense test means that the plaintiffs must provide evidence of actual self-defense shootings, not just ownership. So they're trying to draw a distinction between ownership and the actual in common use for self-defense. So they're saying ownership is not enough. But here again, the judges don't seem to really buy that argument. The judges push back against that statement, saying that Heller and Bruin, in both of those cases, none of the parties, none of the plaintiffs, defendants, government, whoever, none of them showed any statistics on actual self-defense occurrences for handguns, simply that there were handguns that were owned by individuals, and that was sufficient enough under Heller and Bruin. They also pointed out that the same was true in the Caetano stun gun case, that it was that simply 200,000 stun guns were owned across the US, not that 200,000 stun guns were used for self-defense. So again, the state of Maryland is trying to draw a distinction between Bruin and what's going on here in Colby, but the judges, in my opinion, just didn't buy those arguments. Also, there was significant pushback by the judges on the argument that they needed to remand the case back down to the district court for further evidence to be developed on discovery. The two judges here argue that the Supreme Court itself actually rejected that type of approach in Bruin. In Bruin, the Supreme Court did not remand the case back down. They did the analysis on their own. They looked at the evidence before them and came to their determination. They didn't remand the case back down to the district court. If you want to know maybe the sense of how this will go, the fact that the state's attorney was laughed at by the judges when his time ended should be a really good indicator. The judges made a passing comment about how they would love to hear more of the state's arguments when his time was up. So that was really interesting. The judges almost enjoyed hearing the state's weak arguments. They pushed back against all of those arguments. And really all they had to do was rely on Bruin. They just kept pointing back to Bruin and how the Bruin opinion by the Supreme Court really contradicts what the state is arguing. So currently we are waiting for the Fourth Circuit's decision, but my impression from the oral arguments, if you listen to them, is that this is likely going to be a 2-1 decision in favor of striking down the Maryland ban on so-called assault weapons. And it's likely going to strike it down as facially unconstitutional. Then the state of Maryland will have to make a very hard decision. They will have to decide if they want to take this up en banc on review and eventually maybe risk the case going up before the Supreme Court once again. But that would be very interesting because of the Supreme Court GVRing this case already. So this is going to be a very interesting situation. But my sense from the oral arguments is that this is going to go 2-1 in our favor. But that's just a quick update on what's going on in a critical assault weapon ban case. There's a lot of other cases that are going on right now nationally. This is one of those ones that's kind of at the highest level that we should keep our eyes on, especially because the Supreme Court recently GVR'd this case, sent it back down to be reconsidered in light of Bruin. If we get any more information, I will let you all know. But if you want to learn more about what's going on in the two-way world, what's currently going on in our battle for our right to keep and bear arms, you can watch these videos here on the screen. But as always, thank you all for watching. Don't forget to like and subscribe. And don't forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.